How to find out about an immigration client's entry record. A client's complete entry and exit history to the United States is a crucial piece of information to gather when evaluating an immigration case. However, sometimes it is challenging to understand or even obtain this information. If the client is unsure of the details of their entry and exit history, do not just rely on their memory. Make FOIA requests with the Office of Biometric Identity Management and Customs and Border Protection. You will need either an alien registration number or an original fingerprint card for the client when making an OBIM FOIA request. You can start an FOIA request to CBP here. CBP records on border apprehension and entries and exits may not be available prior to 2000, in which case you may consider submitting an FOIA request to USCIS for an A file. You can find the instructions here. You can start an FOIA request with the OBIM by first registering here, after which you may submit FOIA requests through their portal. You may also consider requesting FOIA records of visa applications from the Department of State. There are generally 4 possible outcomes concerning client entry and re-entry. 1. They enter the country without inspection. 2. They make it into the country with inspection and admission or parole. 3. They are apprehended by CBP and returned. 4. They are apprehended by CBP and given expedited removal. The first 2 result in an entry, and the second 2 usually do not. It is critical to understand the differences between the last 2 outcomes, voluntary return and expedited removal. Generally speaking, a voluntary return will not affect the ability to immigrate in the future. An expedited removal, however, can have several legal ramifications. If you suspect that your client was expeditiously removed, you should do OBIM and CBP FOIA requests to confirm. You can also do an FBI background check. And make sure to ask your client if they received any documentation when they were apprehended. If apprehension took place before April of 1997, it is likely that the apprehension was voluntary unless the client appeared before an immigration judge. This is because expedited apprehensions were not implemented until 1997. If you determine that your client made an entry into the U.S. without being apprehended, the next step is figuring out the type of entry and the legal implications. An entry with a visa or other document is the most straightforward type of entry, made by someone who presents themselves at a port of entry with a valid visa. An entry without inspection means that the non-citizen had no interaction with immigration officials and came into the U.S. undetected. If someone's last entry was without inspection, they are typically ineligible to apply for permanent residency based on employment or family petitions from within the U.S. A client might tell you that they came to the U.S. unlawfully or illegally because they had no lawful basis for coming into the U.S. This may lead you to assume they entered without inspection, but if they were allowed to enter the U.S. after presenting themselves to a border official for inspection, even though they lack documentation, that is a lawful entry or admission for purposes of adjustment of status. The only exception is if this person falsely represented themselves as a U.S. citizen. It is important to understand these different types of entries and exits and the legal implications they might have on your client's immigration status. Always be sure to consult with your client for documents and/or use the links provided on this video. Do not rely upon memory. If you have any questions or seek any legal advice, please call Attorney Jane Wiley's office or visit Jane's website.